Hi everyone, this is Professor Opterbeck. I'm dropping this video just to say hi at the beginning of week 2 of our International IP course. I was very pleased to see your discussions and your responses to the forum post during week 1. I think many of you really put your finger on some of the things that we'll be seeing throughout the semester. One thing a number of you mentioned was the ambiguity of words, and in particular the words used in some of these international treaties. And you're right, some of these words are ambiguous, and all of them get lawyered, and they get lawyered throughout the world. So you do see differences in national law and between different courts in how these treaties, what they're thought to mean and how they play out. Another thing a number of you mentioned was the importance of the internet, and that's right as well. As we see, this international trade system and this system with intellectual property starts in the 19th century. The kind of contemporary international or modern period international trading system starts after World War II. And then the internet comes in sort of the early to mid 1990s, the public internet comes at that time. And we see responses to that. And the TRIPS agreement in particular, including its pharmaceutical issues, is also right in that same time period. I think another thing you'll begin to see is kind of the growth of that international trading order after World War II, but also its contraction, really beginning in the economic crises of the 1970s, but kind of ebbing and flowing, but becoming increasingly important today in the US and in other countries as there's this greater emphasis on nationalism. So we'll see some of that tension play out as well. As we move into this week, you'll see that this week really focuses on the European Union. The EU, of course, is one of the most important trading blocs in the world. It's one of the US's most important trade partners. The EU has strong views on intellectual property, many of which are similar to the US, but which in some ways differ, in particular in this relationship between dynamic and static competition and the way the EU views antitrust in that space and particularly in cyberspace. So we'll see some of those similarities as well as some of those differences. This week is really kind of a foundational week for the EU to get that under your feet a little bit. And then next week, when we move into the beginning of substantive law of copyright, we'll start to see how some of these play out in different areas of substantive law. So I hope you're all well. I hope you have a great week. And as always, if you have any questions or anything, feel free to reach out.